Hi, this narrated PowerPoint is all about types of speech that are outside First Amendment protection. There's essentially three types of speech that are not protected by the First Amendment, mostly because the court has come to the conclusion that they don't offer anything of value to public discourse. We're going to talk about two of them, and I did ask you to read some material from the annotated Constitution about these unprotected types of speech as well. So the three types of speech that are not protected by the First Amendment include libel, which we'll talk about, obscenity, which mostly these days deals with pornography, and fighting words. And the reason I'm not going to spend a lot of time talking about fighting words is because even though, gosh, nearly a century ago now, the Supreme Court ruled that fighting words are not protected speech, their definition of fighting words is so narrow that most laws that were designed to punish people for using fighting words have been struck down as being either not content neutral or so narrowly drawn that they they amount to sort of viewpoint bias. So in theory, fighting words are not protected, but a lot of people get fighting words mixed up with hate speech, and hate speech actually is protected under the First Amendment. Fighting words are words that have no purpose other than to provoke a violent response from somebody else. And most language, most speech has a purpose beyond just pissing somebody off. So we'll talk about libel and obscenity. You should know that fighting words are not protected, but there aren't very many court cases where the court has recognized fighting words and allowed them to be restricted. So we're going to talk about libel though. So there's two different kinds of defamation of character. One is called libel and the other is called slander. The difference between the two is that libel is written down or broadcast on the radio or television or via social media or the internet, and slander is specifically words that are spoken that aren't captured, so words that are spoken that nobody records or anything like that. So mostly we talk about libel, even though they're both technically the same thing. They're language that defames someone, calls into question their honesty, or says something that is false about them and causes that person harm. And there's two different standards for libel. So first of all, you should know libel is a civil matter, right? We don't put people in prison for libel, but an individual person who feels that they've been libeled can win a monetary settlement in court if a jury finds that the standards of libel have been met. And so we're going to talk about what it means to libel somebody who's just an ordinary person like me, and probably most of you, and what it means to libel somebody who's actually a public figure. The standards are very different, and I'll tell you why. So libel of an ordinary person. Let's say the Sacramento Bee publishes a story, or CNN does a news story about an ordinary person. This isn't a person who makes their living in the public eye. They're not a politician or an actor or a singer. They're just an ordinary citizen, and the media publishes something about them that they feel is libelous, that they feel defames them. And so they file a lawsuit. They take, say, CNN to court, and they ask for millions of dollars in compensation for having been defamed by CNN. Well, the jury's going to be asked a couple of questions. The first thing that's going to come into play is what was said about that person in fact false, right? If CNN does a story about somebody and accuses them of a crime, for example, and it's a false statement of fact. They, in fact, did not get arrested for that crime, or they did not get convicted of that crime, and CNN said that they did. That's one of the things that's necessary to win a libel case is that you have to demonstrate to the satisfaction of a jury that what was published about that person who's filing the lawsuit was in fact not true. Truth is the defense against libel. If something is published about somebody that is true, it may demean them, it may defame them, but if it's true, it's not libel. The other thing that's not libel is somebody publishing something negative about another person or a group of people that is a statement of opinion. So if, for example, somebody published something that said, she looked like she's been having a really difficult time lately, and I wonder if, maybe there's something going on in her marriage or something. I hope not, right? That's an opinion. I think that she looks like she's worried about something, and I hope that it's not, something having to do with her marriage or whatever. That's a statement of opinion. Or I went to a restaurant the other night and I had the worst meal of my life, and I'm going to publish a really nasty review on Yelp. Well, if somebody's just expressing their opinion, that's not a matter of fact. That's not a factual statement. Now, if somebody said, I got food poisoning from this restaurant, and it can be proven that the person didn't get food poisoning, then that's a false statement that was made, right? So first of all, the statement has to be false. What's published has to be false in order for it to be libel. And then there has to be some level of harm attached to it. So if a newspaper prints a picture of a group of people and they mislabel it and they claim that one person is another person, they get them mixed up, right? They have in fact published something false about someone because they called them by the wrong name. But if it doesn't cause any harm, then that's not libel either, in general. So something that would cause harm would be, for example, if somebody suffered a financial setback as a result of what was published. They lost their job, or they couldn't get a loan at a bank, or if they suffered emotional distress, they got bullied, or they got death threats or something like that. That might be something that a jury would take into account. But one of the biggest ways that a media outlet, for example, could defend against libel is by arguing that what was printed about the person was in fact true. Most legitimate media sources are pretty careful about what they publish about ordinary people. Part of the reason an ordinary person gets protected against libel is because the press has a lot of power. Words can have a big impact on people's lives, and most ordinary people don't have access to the media to clear their name, right? What gets published about them could have lasting effects that they can't fix because we're just ordinary people, and if we call a press conference, nobody's going to come. Public figures are different. Public figures do have access to the media, and public figures are engaged in matters that the public cares about. This is especially true about people who are in elected office, who are literally public figures, but also candidates for office, somebody who's running for office, who's putting their name out there as somebody you should vote for. They're considered public figures. Most people who make their living in the public eye don't have the same level of protection against defamation as ordinary citizens do, because one, they're engaged in matters that the public cares about or that the public has a right to know about, especially campaigns or things that people do when they're in government, right? The actions of people in government. Think about the impeachment process, for example. So up until 1964, there actually wasn't a different standard for libel of a public figure. And so the media had to be exceptionally careful about what they printed about someone, because a public figure might go running to the courts anytime something bad was said about them that happened to be in error. But in 1964, a case came before the United States Supreme Court called New York Times versus Sullivan, and it actually involved this ad that was taken out in the New York Times by civil rights activists. And one of the things that they claim in this ad, if you read this ad, is that police in parts of the South, and they named Sullivan as a police commissioner who had been engaged in activities against civil rights workers, including jailing them and setting police dogs after them, turning fire hoses on them, etc. And it turns out that Sullivan didn't actually do some of the things that he was accused of. So he sued the New York Times for libel, and under the existing standard, where public figures are treated just like everybody else, he won. But when the case came to the United States Supreme Court, the Supreme Court established a higher standard for public figures to win a libel lawsuit. And the reasoning was that unless the media is free to engage in debate about important issues, if they have to worry that every single thing they print has to be absolutely proven to be true before they can investigate wrongdoing or publish stories about possible corruption in government, then they'll be stifled in a way that is detrimental to the public good and to the public's right to know what's going on in their government and to hold their government accountable, including candidates for office, etc. And so the court established in New York Times versus Sullivan a third thing that public figures have to demonstrate before a jury is supposed to award them a libel settlement. And this gives the press greater leeway when covering public figures. They don't have to worry that every single word that they print is absolutely 100% provable to be true. They can publish allegations, they can publish speculations and that kind of thing in the interest of public knowledge. So a public figure filing a libel lawsuit would still have to show that the material printed about them was false. They would still have to prove or demonstrate that it caused or could have caused some sort of harm to them. But they also have to meet this third standard. And the standard is called the actual malice standard. And the judge would ask the jury to determine whether or not the material was published with actual malice, that the reason it was published was to defame, that they weren't really interested in public discourse. What they really were trying to do is call this person's fitness for office or accuse this person of corruption in office, not for the public good, but out of malice. And actual malice is defined by the court as knowingly publishing something that's false. In other words, they made it up. They knew it was false and they published it anyway, or they published it with reckless disregard of the truth. And that would mean they didn't check their sources. They didn't try to get another source to back up what was being said by source number one. They didn't do any sort of the regular due diligence that a journalist would be expected to do before they publish something as factual for the public to view or watch or read or something. So actual malice is a really hard standard for public figures to meet, in part because most legitimate news sources don't knowingly publish stuff that's false. They don't have an incentive to do that because their respect in the community, if you're a legitimate news source, is based on whether or not people feel they can trust what is published or what is broadcast. This is why some, they're not really news outlets, some organizations or blogs or individuals who publish quote unquote stories on their blogs or on their websites don't call themselves news agencies. They call themselves entertainment entities. Nonetheless, some of them still can get into trouble if they publish things. The most famous one that's going on right now is the guy who runs InfoWars, Alex Jones, right? InfoWars is not a legitimate news source, but they publish material that appears to be presented as legitimate news. And Alex Jones is being sued for defamation by some of the families of the Sandy Hook shooting because he claimed in InfoWars that they were actors, that nobody actually died in the Sandy Hook, that the kids who were shot and the teachers who were shot, that it never happened. And his defense is in part one that he's got some psychological problems, but he's also making the argument that InfoWars is not a news outlet. And so they shouldn't be required to publish things to the high standard that newspapers are. It's kind of weird. Who knows what's going to ultimately happen with that case. He's lost mostly in the lower courts. So libel of a public figure is much more difficult for a public figure to prove. Some people think that the press has too much protection from libel lawsuits, including the President of the United States. This is what Donald Trump said before he got elected president when he was talking about libel. He said, "I'm going to open up our libel laws so when they write purposely negative and horrible and false articles, we can sue them and win lots of money. So when the New York Times writes a hit piece, which is a total disgrace, or when the Washington Post writes a hit piece, we can sue them and win money instead of having no chance of winning because they're totally protected." Well, that's not true. If they publish horrible and false articles knowingly, and they do it on purpose, then presumably somebody like Donald Trump or Hillary Clinton or any other public figure could win a libel lawsuit. It's just very difficult because what is not covered under libel are opinions. So if somebody writes an editorial that says, "I think this person was guilty of this, and here's why," that's not libelous, because it's a matter of opinion, not presented as a matter of fact. So we haven't changed our libel laws. Mostly it's a state matters. Sorry, that barking sound you heard was my sister calling me on the phone. So I paused and now I'm back and I've got to catch up on where I was. So anyway, so that's a libel of a public figure. And the last thing that I wanted to tell you about libel is an exception to the actual malice standard for public figures. And that is for satire and parody. In 1988, a case came before the Supreme Court called Hustler versus Falwell. Jerry Falwell's son is the guy who's been in trouble in the news lately. He had to resign his position with the university that his father founded. Jerry Falwell is no longer alive, but at the time he was the leader of an evangelical Christian organization that was very influential in the 80s and certainly to this day, but certainly got started in the 80s. They're mostly super anti-abortion and anti-pornography, etc. And one of the targets of Jerry Falwell was the publisher of Hustler magazine, which is a pornographic magazine named Larry Flynt. And so in his magazine, Hustler magazine, Larry Flynt published this ad parody. Campari is an actual liquor, but this ad parody is pokes fun at Jerry Falwell for his religious beliefs, and essentially it's a fake interview with him where instead of talking about the first time he drank Campari, he talks about the first time he ever had sex with his mother and a goat in an outhouse. So Jerry Falwell was hugely angry and embarrassed about this ad, and so he filed a lawsuit against Hustler magazine claiming emotional distress and defamation, arguing that Hustler magazine published this with actual malice, that they intentionally made up this ad to bring him into disrepute and to harm his reputation. And Larry Flynt said, yes, we did. But it wasn't published as a factual piece. It was published as an ad parody, as using satire and humor to make a point about Jerry Falwell, that they thought he was hypocritical, that they thought that he didn't stand for things that they stood for, etc. If you can't really see it in this PowerPoint, but if you look right at the very bottom, it says ad parody, not to be taken seriously. And so when the Supreme Court was asked whether they should uphold the judgment that a lower court had given to Jerry Falwell, saying, well, it's actual malice, so it must be libel, the Supreme Court reversed, and they said that satire and parody has a long history, not just in the United States, but all over the world, as a way for people to make a point using humor and using parody as a way of expressing, in this case, political points of view. And so there is an exception. So when Saturday Night Live pokes fun at people and has people dress up as Sarah Huckabee or Joe Biden or Barack Obama or whatever, even if they are using their humor to make them look bad or to poke fun at them, the Supreme Court has made it pretty clear that that's not libel. Libel is material that's published in a way that could be expected to be believed as true. And satire and parody is not. So that's what I had to say about libel. The last thing that I want to talk about in this PowerPoint is obscenity, because the Supreme Court has ruled that obscene material is not protected by the First Amendment. It is outside the protection of the First Amendment, but indecent material is protected. So mostly what we're talking about is pornography. The courts have allowed what we call, and is the subject of the other narrated PowerPoint for this week, time, place, and manner restrictions on, say, obscene language. So there are certain times of day where broadcast media can't broadcast certain kinds of language, mostly having to do words, bad words, like the F word and that kind of thing. But mostly when we talk about obscenity from a Supreme Court perspective these days, we would be talking about pornography. Obscene pornography is not protected by the First Amendment. Indecent pornography is protected by the First Amendment. And the question, of course, is how do you tell the difference between something that's protected and something that's not? Now, if you're not a purveyor of pornography or you're not interested in pornography, this question may be not very important to you. But if you make your living producing, distributing, selling pornography, you want to make sure you stay on the right side of the First Amendment, right? So there has to be some sort of guidance. I asked you to read a bunch of sections in your annotated Constitution about indecent versus obscene and what the court has said. So I will give you a little bit of information that I think is important. So one of the tasks that the court has had in the past is to try to come up with a definition of obscenity that governments could use to determine whether or not they could ban something from being sold, like in their city or in a liquor store, or liquor stores you can buy pornographic movies and stuff. And so when we first started talking about obscenity and what's allowed and what's not, one of the first standards that the court used was this thing called the Roth test, R-O-T-H. And what the Roth test said was that material is obscene if it appeals to what's called the prurient interest in sex. In other words, it has to be material that it's designed to entice abnormal sexual drives. So something like Playboy magazine, where you're looking at pictures of naked women and maybe you get kind of lustful, that's normal, according to this definition. But obscenity would be something that was designed to appeal to a sort of what's considered an unnatural interest in sex, like bestiality, having sex with animals, or sadomasochistic sex and that kind of stuff. That's what the court had to determine what kinds of things could be punished and what kinds of things couldn't be punished. And under this Roth standard, the standard was that the material had to be completely lacking in any kind of social or artistic value. So the standard was really easy for pornographers to get around because they could put together a video where, 59 minutes of the video is something that could be banned. People having sex with animals or something like that. And then at the very end, they would put something that had redeeming social value, like the woman wakes up from a dream and goes to church or something. I don't know. And so as the court became more conservative, as the 60s ended and into the 1970s, when more conservative people got appointed to the Supreme Court, they wanted to find a way to allow local governments, which might be more conservative in some parts of the country than in other parts of the country, to ban things that would not be that they didn't think would be appropriate in their own community. And they wanted to get away from this relatively permissive standard that was established in the Roth case. And so in 1973, they found a case that they could use to develop a new test for whether something was obscene and could be banned. In other words, you could ban the manufacture and distribution of pornography in that geographic area. They found that test in a case called Miller versus California and established what's called the Miller test, which is the current test for obscenity. I will tell you that very little comes to the court these days having to do with obscenity. In pornography involving adults is very rarely challenged in the courts anymore. Our standards have sort of changed over time. But in the event that a video, mostly videos now, gets challenged, somebody goes into a store and they see a video that they think violates their local obscenity standard, they could go to the district attorney and ask that the shop be made to not sell that anymore. That's how it would generally work. So here's the test. The current test is the material has to appeal to an unnatural interest in sex, which gets most magazines and stuff off the hook. So Playboy magazine, Penthouse, Playgirl magazine, if it's still being published, I don't know. They mostly appeal to the sort of normal, healthy, lustful sex drive of people. Secondly, the work taken as a whole, not one little sentence, but taken as a whole, the work has to lack serious literary, artistic, political, or scientific value. This is sometimes referred to as the SLAPS test, which is actually pretty funny if you are a 12-year-old boy. So serious literary, artistic, political, or scientific value. So there's a lot of stuff that could have obscene-ish sexual content, but has also artistic or literary value. So most things that are written are probably not going to be banned as obscene because they have literary value. Certainly statues and paintings and those sorts of things have artistic value, political or scientific value. So scientific value might be a sex manual or something like that. And what the Miller test says is you take the material as a whole and you look at it, and a jury would look at it and make a determination of whether or not, on the whole, it doesn't have any serious literary, artistic, political, or scientific value. If it does have literary, artistic, political, or scientific value, then it is by definition not obscene. It might be indecent. Playboy magazine is considered indecent, but it's not considered obscene. And under the Miller test, it's up to local governments to decide what is obscene within their local community. And that means they have to write it down somewhere. So in a lot of cities, including, I think the city of Sacramento still has an obscenity standard where it's written down what is considered obscene in this community. It usually includes sadomasochism and bestiality are two things. Some might have orgies, like videotaping of orgies or something like that. And so if somebody stumbles across something in their community that they think is obscene, the community has to already have a standard on the books that that piece of material could be judged against, and it would be judged by a jury of reasonable, average people from the community would have to watch the video or etc. So that's the Miller test for defining obscenity. Not very much happens under obscenity standards anymore. There's not a lot that gets banned anymore, but that's the test. So here's how it's been sort of regulated over time, some cases that are kind of important about obscenity. In 1969, in a case called Stanley versus Georgia, the Supreme Court ruled that what can be regulated is the manufacture and distribution of pornography. But pornography, a person can't be punished for possessing pornography in the privacy of their own home. So a local community might try to stop that pornography from being sold in their community, and the internet brings up all kinds of other questions. Whose local standards do you follow if you're downloading something from the internet? But once somebody has pornography in their possession, they cannot be punished for that. So the private enjoyment of pornography is protected under the First Amendment. In Jenkins versus Georgia, the court established not a strict standard for what local governments could ban, but they said that local governments can't be so restrictive that they would ban things that most communities wouldn't ban. So in this case, there was a movie in the 1970s that by today's standards is really tame in terms of pornography. It was called Carnal Knowledge, and it was obviously about sex. And a theater in Georgia, they wanted to ban it from being showed in the theaters, and the Supreme Court said, this is too strict. This local ordinance is too strict, that local governments can only ban things that are truly obscene, and that they said this is indecent, but you can't just say everything is banned if it has anything to do with sex. And so Jenkins versus Georgia. And then this case is actually really important for free speech in this area. Congress passed a law called the Communications Decency Act, and parts of the Communications Decency Act are still in effect, but one part of the Communications Decency Act made it a federal law to allow a minor to access indecent or obscene material on the internet. So in theory, somebody could get arrested if their kid accessed pornography on their home computer. And the idea was that they would try to get pornography industry companies to somehow filter out their material so that it can't get in the hands of kids, which is why they would put you have to be 18 to enter a site or whatever. But the Supreme Court struck that provision of the Communications Decency Act down in 1997, and they said what Congress had done was essentially regulate the internet to the point where adults were only allowed to see things that were fit for children. And they said that the law was an unconstitutional violation of adults' ability to access indecent material that might not be fit for a child, but would be okay for an adult. And so essentially it was too heavy-handed. It had gone too far. It would have stifled speech for adults in the interest of protecting children. And so the court struck that down. Like I said, there's not a whole lot of cases that come before the court dealing with obscenity in relationship to pornography that is created using adults. Child pornography is a completely different standard. There is no such thing as indecent child pornography. Pornography that is created using actual children. under the age 16 or younger, but 18 is part of the standard in some places as well, is inherently obscene. It is by definition obscene. So, and that includes showing children having sex, not kissing, but actually having sex, or lewdly displaying their genitals, that kind of thing. That is inherently obscene. There's no defense that a pornographer could use and say my child pornography is merely indecent. It's not obscene, because it's obscene by definition. And the argument is that the government has a compelling interest in protecting children from harm. And since children can't consent to have sex legally, videotaping them, even if they think they're consenting, they're 16 years old and they think they're consenting, or they're 15 years old and they think they're consenting, they can't. It's inherently harmful. And the court said that the government's interest in guarding against child pornography is like hugely important. And so it is illegal not only to manufacture and distribute pornography, but it's also illegal to possess it in the privacy of your own home or on your computer. This standard was set actually in 1982 in a case called New York versus Ferber. Ferber was a pornographer who made child pornography that he thought was indecent but not obscene. And if an adult had been videotaped doing what Ferber videotaped children doing, it would have been protected under the First Amendment. So he thought he was protected. But New York had passed a law that said that if children were used in the manufacture of pornography, that it was automatically obscene, and the Supreme Court upheld it in 1982. And they said that it is within the government's power to regulate child pornography in this way. And so it is illegal to manufacture, distribute, or possess child pornography. And the government spends a lot of money every year trying to track down child pornography. Is unfortunately a relatively robust business on the internet. But it has to be pornography that's actually made using actual children. In 2002, the most recent case having to do with child pornography, the Supreme Court struck down a federal law that made it illegal to manufacture, distribute, or possess virtual child pornography. In other words, pornography that depicts children engaging in prohibited behaviors, but they're computer-generated children rather than actual children. And the Supreme Court ruled that where there is no actual harm to an actual child, there can be no restriction. And so they upheld the manufacture, distribution, and possession of virtual child pornography as being protected under the First Amendment. This was a very controversial decision. Not everybody agrees with that. So sometimes when we talk about the First Amendment, we have to learn in college about things that might make people uncomfortable. So I'm sorry if this made any of you feel uncomfortable, but it's important when we study the First Amendment to talk about how the court determines what's protected and what's not protected.